Good morning, everyone. This is Len Gordon at Venable. I'd like to welcome you all to our virtual ad law CLE Bonanza. This is the first of 3 sessions. Today, we'll be talking about recent developments or upcoming developments at the Supreme Court that could fundamentally change both the FTC Act and the TCPA. Tomorrow, we've got a great program on COVID-related consumer protection issues, including participation from Rich Cleland at the FTC. And on Thursday, we've got a great program with the attorney advisors who work with each of the 5 FTC commissioners. Thank you for joining, and hope you're having a great day. And with that, I'm going to get started. We have a lot to cover. During the middle of the presentation, we'll give you the secret code for CLE Credit for those of you who need it. And this program will be recorded and pushed out towards the end of the week. So I'm going to talk about the FTC's enforcement authority with Mary Gardner, and Steve Freeland will be covering the TCPA issues. So this fall, the FTC's authority to go into court under Section 13B of the FTC Act will be considered by the Supreme Court and could well be considerably limited. Section 13B of the FTC Act provides, whenever the Commission has reason to believe that any person, partnership, or corporation is violating or is about to violate any provision of the law enforced by the FTC, and that the enjoining thereof would, pending the issuance of a complaint by the Commission, and until such complaint is dismissed by the Commission or set aside by the Court on review, or until the order of the Commission made thereon has become final, will be in the interest of the public, the Commission may bring suit in District Court of the United States to enjoin any such act or practice. Provided further, and this is called the second proviso, that in proper cases the Commission may seek, and after proper proof, the Court may issue a permanent injunction. So as you can tell from the text used there, this provision was added in 1973 to allow the FTC, when it was conducting administrative litigation, to stop ongoing violations of the law, including primarily antitrust mergers that were going to happen that the FTC was going to challenge. This was enacted before the Hart-Scott-Rodino statute. And for the first 8 years or so of the statute, that's really how it was used. The FTC did not take a bold view of the powers there. It continued to bring most of its cases, as it had for the first 70 years of its existence, in administrative litigation before administrative law judges at the FTC, and to continue to promulgate rules that would inform businesses of conduct that was prohibited. It was consistent with its initial mission to issue administrative cease and desist orders and promulgate rules. Those were the primary tools the FTC was to use to tell businesses what they could and couldn't do and to enforce the law. 2 years after Congress enacted Section 13B, which was actually part of the Trans-Alaska Pipeline Act, it wasn't just an FCC statute, but 2 years later, Congress enacted Section 19 to explicitly grant the FTC the authority to seek monetary relief for harm to consumers. And one would ask, and there'll be a lot of discussion about this today, if the grant of an injunction in Section 13B already provided with it the ability for the FTC to go to court to get dollars, why was Section 19 necessary? And that's a question we'll be discussing a lot today. Section 19 provides that if someone engages in a deceptive act or practice to which the Commission has adjudicated a cease and desist order, then the Commission can go to court to obtain monetary relief. There are some important qualifications on that. One, it's subject to a 3-year statute of limitations. And 2, there's a scienter requirement, a knowledge requirement, which is that a reasonable man would have known under the circumstances that the conduct was dishonest or fraudulent. The FTC has actually brought very, very few cases under Section 19 subsequent to a administrative adjudication. I think the last was maybe 10 years ago. The Commission also can get civil penalties for violations of rules or consent decrees. But then again, they must show actual knowledge that the conduct was unfair, deceptive, and prohibited by the Commission. Indeed, the Commission can even get civil penalties against companies or individuals that were not subject to the cease and desist order if the Commission can show that the person or corporation had knowledge of the cease and desist order and knew that its conduct violated the cease and desist order entered against another entity. Again, the Commission is very, very seldom, if it's ever, or I guess very seldom, leave it at that, used that authority. But there are tools for the Commission other than Section 13B to obtain monetary relief from defendants, but it's subject to these statute of limitation and scienter requirements. So in thinking about this, it's useful to compare the relief provided for in Section 13B and the relief provided in Section 19. Section 13B says the court may issue a permanent injunction. Section 19 provides that the relief available to the FTC may include, but shall not be limited to, rescission or reformation of contracts, the refund of money, the return of property, the payment of damages, and public notification respecting the rule violation or unfair or deceptive act or practice. Section 19 provides a broad panoply of tools to the FTC. But beginning in the 1980s, early 1980s, the FTC decided that this tool that Congress had given it was too cumbersome to wield. The FTC didn't like having to go through administrative litigation first and didn't like having to meet the knowledge requirements, the scienter requirements of Section 19. So beginning in the 1980s, some creative lawyers at the FTC took a look again at Section 13B and said, well, that authorizes us to get a permanent injunction. That means we can get all of the equitable relief that a court might award under its broad equitable powers under Rule 65 of the Federal Rules of Civil Procedure. And incrementally, the Commission started moving almost all of its consumer protection litigation from administrative actions brought before ALJs to federal court actions invoking Section 13B of the FTC Act. And now, 90% or more of the FTC's cases involving violations of Section 5 of the FTC Act are brought in federal court pursuant to Section 13B. And the remedies that the FTC has sought in those cases has also increased. The FTC has sought, initially it sought equitable monetary relief only in cases involving what they would call hardcore fraud. But over time, the FTC has sought equitable monetary relief equal to gross proceeds, essentially total sales of the product or service at issue minus any refunds, claiming that is equitable monetary relief. It's a tremendous remedy, and again, not subject to a statute of limitations, not subject to a knowledge requirement, and indeed, when the FTC seeks these remedies for total proceeds, it still relies on case law that was developed when the FTC was seeking cease and desist orders that say that the FTC doesn't have to prove that every customer was deceived. It only has to prove that a substantial minority of customers were deceived. And that really creates some tension. If you look at the John Beck case that the FTC litigated in Los Angeles a couple years ago, there was survey evidence there showing that 20, 30% of consumers took away the message, one of the key messages that the FTC was relying upon. But in that case, despite the fact that only 20 or 30% of consumers took away that message, the FTC sought, and the court awarded, and the Ninth Circuit upheld, total sales. So you've got a real juxtaposition there between, only a substantial minority of consumers allegedly being deceived, but the defendant being liable for their total sales. And in pushing this expansion of its powers, the FTC has relied on some Supreme Court cases expressing really an archaic view of equitable remedies. The Porter case and the Mitchell case both said that had a very, I would call it an expansive view of what equitable tools are available from a statute when Congress grants an agency or provides in a statute the ability to get equitable relief. And these cases, at least interpreted by the FTC, authorize the full panoply of equitable powers that a court might impose or might have available to it. But in more recent jurisprudence, primarily in the Megrig case in 1996, the court backed away from this broad interpretation of equitable remedies available out of a statute. And in Megrig, they refused to find an implied restitutional remedy. And the language that they use there has resonance as we think about the FTC's ability to imply this broad equitable authority here, where Congress has provided elaborate enforcement provisions for remedying the violation of a federal statute. It cannot be assumed that Congress intended to authorize by implication additional judicial remedies. And as we'll discuss in a few minutes, that in large part is the issue that the Supreme Court is going to be wrestling with this fall in two cases that are now before it. So the first of those cases comes out of the Ninth Circuit, which has taken historically an incredibly broad view of the scope of Section 13B, both as to the tools available to a court and what the scope of the equitable monetary relief might be. The Ninth Circuit has found that it's proper to impose joint and several liability on people, and taken a very broad view of how equitable monetary relief ought to be measured, including that should really just be measured on total sales minus any refunds. The AMG case involved race car driver Scott Tucker. It was sort of a sexy case, and ultimately the FTC prevailed in a billion-dollar judgment. And some of the conduct alleged there was nasty. And I think, one of the things that's happened over time is, some of these cases involve allegations of really nasty conduct, and judges are persuaded by the FTC that they ought to sort of give the FTC the benefit of the doubt and stretch the bounds of the statute, try and do what it can to make consumers whole. So the district court awarded $1.27 billion in equitable monetary relief. And the Ninth Circuit affirmed, relying on its past precedent, that Section 13 empowers district courts to grant any ancillary relief necessary to accomplish complete justice, including restitution. Extraordinarily broad view of Section 13B. But in a very thoughtful concurring opinion, Judge O'Scanlan wrote, expressing great skepticism over the FTC's authority. And she noted that, injunction has been turned into this incredibly broad and somewhat ill-defined tool to get really whatever the FTC wants from the defendant, and that the Ninth Circuit was disregarding more recent Supreme Court precedents, including Megrig and the Kokish case, in which the Supreme Court expressed some skepticism about broad equitable monetary relief, that it might, in essence, become a penalty subject to a statute of limitations. Judge O'Scanlan urged the Ninth Circuit to reconsider the case en banc. That's why she wrote a concurrence, but the Ninth Circuit passed. The other case is the Credit Bureau Center case out of the Seventh Circuit. And there was a credit monitoring service that, allegedly consumers were not adequately told they were being enrolled in. Another significant award. And this one went up on appeal. The Seventh Circuit affirmed the judgment as to liability, but overturned the restitution award, and indeed overturned its prior precedent in Amy Travel, which was one of the first cases that adopted the FTC's broad view of the scope of Section 13B. And the case was circulated for potential rehearing en banc, but the judges of the Seventh Circuit did not take that up. So the panel's decision to overrule the prior precedent in Amy Travel became the law of the Seventh Circuit. The Seventh Circuit's opinion relied heavily on the Meg-Rig decision as undercutting the Porter and Mitchell cases and really bringing into sharp focus the notion that where Congress has provided specific remedies in one part of the statute, courts should not infer broad equitable powers simply because the statute grants the ability to obtain an injunction. So both of these cases have now made their way to the Supreme Court, and they have been consolidated. The briefs for both AMG and Credit Bureau Center were filed yesterday. And what I'll do now is try and summarize for you the arguments. But the issue that's going to be before the Supreme Court is whether Section 13B, by authorizing injunction, also authorizes this broad equitable monetary relief, and if so, how it might be measured. So the arguments that the two different sets of defendants have made, and they're two separate briefs, the case will be consolidated for oral argument, and I think each of the defendants will have some time. But the arguments are very textual and pretty straightforward. First, the defendants argue that injunction means an injunction, and injunctions are forward-looking tools. They are meant to stop someone from doing something in the future. They are not meant to remedy past illegal conduct. They also note that an injunction is really meant to deal with situations where the harm suffered is irreparable, where legal remedies are inadequate, and that's clearly not the case here. The Congress has provided for legal remedies to make consumers whole, so there's no need to infer that right under Section 13B simply from the grant of an injunction. In defending their broad interpretation of Section 13B in the past, the FTC has said, well, they're simply returning lost property to consumers. And that's a traditional tool used in equity. And the defendants, I think, aptly point out that we're not dealing with situations where Steve Freeland has taken my horse and I go to a judge to have the horse returned to me. We're talking about money, a fungible good, and that the notions in the common law, in equity jurisprudence about courts being authorized to order the return of a good don't really apply to money, and that it really is twisting the remedy to find that it does so apply to an injunction and to money. Excuse me. They also note that restitution is not an injunction. Restitution is a damage award. It's something to make someone whole for that which has happened in the past. Again, not an injunction. So looking at the plain language of the statute, the defendants all argue that the statute authorizes an injunction and only an injunction, and therefore broad equitable monetary relief is not appropriate. Next, the defendants argue that it is improper and inappropriate to infer such a broad equitable remedy because in Section 19, Congress authorized a mechanism for the FTC to obtain monetary relief on behalf of consumers. The defendants point out that the FTC essentially found that mechanism inconvenient and cumbersome, and so created their own mechanism relying on Section 13B as a hook. So as we looked at initially, Section 13B was not meant to provide the FTC with a broad tool to remedy past conduct. Indeed, as clear on the face of the statute, Section 13B was added to the FTC Act to allow the FTC to stop ongoing conduct pending a administrative law proceeding, and in certain proper cases to obtain a permanent injunction in that case. But again, the whole notion of that section is that it deals with situations where the defendant is violating or about to violate the law, not in situations where there's something that needs to be done to remedy past wrongdoing. Further supporting the argument that broad equitable monetary relief ought not be inferred based on the grant simply of the power to obtain an injunction, the defendants note that Section 5L of the FTC Act, which deals with violations of cease and desist orders, authorizes the FTC to obtain mandatory injunctions and such other and further equitable relief as deemed appropriate to redress violations. So elsewhere in the FTC statute, when Congress meant to provide the FTC with the ability to obtain other ancillary equitable monetary relief or other equitable relief, it used words to indicate that intention. In Section 13B, Congress simply used the word injunction. The defendants also note that the powers available to the FTC under Section 13B and the scope of the remedies available under Section 13B are far broader than those available to the FTC under Section 19. Again, there's no statute of limitations. There's no scienter requirement. There's really no requirements. It's sort of playing tennis without a net. And the defendants argue, I think quite appropriately, that it's somewhat a nonsensical statutory scheme if under Section 19 the FTC has to make this heightened scienter showing and is limited by a 3-year statute of limitations. But in Section 13B, they can essentially, they're not so limited. It makes Section 19 essentially meaningless, and that's been borne out by the fact that the FTC has so little used Section 19 and the maxim of statutory construction that statutes should not be interpreted to render other provisions meaningless. And the defendants argue that the Porter and Mitchell cases should either be limited to their facts or overturned, and that the Megrig case is the better law. The defendants also point out that the FTC has largely abandoned its rulemaking function and providing notice to industry through consent decrees, and instead litigated consent decrees that sort of spell out the Commission's reasoning and educate businesses about what to do and not do, and instead become a consent order factory where defendants are compelled to settle with the FTC because the FTC holds over their heads the sword of Damocles of total sales as equitable monetary relief. And that's a remedy that very few companies can withstand, especially small companies. And so rather than issuing rules and litigating consent decrees, the FTC issues consent orders and then sometimes seems to take the position that those consent orders put industry on notice even when they're not litigated. So that's a byproduct of this, and the defendants appropriately, I think, call that out, that the effects of this broad interpretation of Section 13B have real consequences. The defendants note that there are also other tools available to consumers. Every state has a mini FTC Act. Many of those states allow for private rights of action, including private rights of action through collective action or class action, and which state attorneys general enforce. And almost all of those statutes, or all of those statutes, have tools that allow consumers to get their money back. So that, you know, the FTC's claims that, you know, this broad interpretation is necessary or consumers will have no way to obtain redress is just not borne out by the facts. And then the defendants argue that even if there is some equitable monetary relief that's available, the way the FTC has measured it historically is not appropriate. And I'll talk about that in a second, because it really stems out of a case that the Supreme Court adjudicated at the end of last term involving the Securities and Exchange Commission, known as LIU, L-I-U. Mary, you want to sort of talk about how the lower courts have dealt with AMG and Credit Bureau being at the Supreme Court?
Yes, thanks, Len. So in the wake of the Supreme Court's grant of cert in AMG and Credit Bureau, numerous defendants in FTC enforcement actions have sought to stay those proceedings. And unfortunately, from the chart we've created here, you can see that a lot of those have been denied. I think, though, that there are certainly some themes that you can take from these cases to demonstrate when a court is more likely to grant a stay versus deny it. So, for example, in FTC v. Kutzner, the court, Kutzner was asking for a stay of enforcement of an already entered judgment. In fact, judgment had been entered against Kutzner in September of 2017. So the case was entirely closed at the time that they asked for the stay of enforcement. And then you can contrast that with the FTC v. Lending Club case. FTC v. Lending Club was the parties were gearing up for trial at the time that Lending Club asked for a stay, and the court found that to be really relevant to granting a stay, that the case was further along. They were past summary judgment, they were already filing trial briefs, and the court found that because monetary relief would be such a major issue at the trial, that it warranted a stay. Now, then you have these in-between cases. So looking at Simple Health and Hornbeam and Cardiff, in all of those cases, the cases weren't so close to trial that the issue of monetary relief was, in these courts' opinion, an integral issue. So, for example, in Simple Health plans, at the time that Simple Health filed its motion to stay, the court had just set a discovery schedule. And so the court said that at this phase of the litigation, whether equitable monetary relief was warranted and what the scope of that equitable monetary relief looked like had no bearing on liability. And they were at such an early stage that they still needed to determine liability. Similarly, in the Hornbeam case, although the court recognized that at the time discovery was almost complete, the parties were just finishing third-party discovery at that point, that there was still, the liability issue was still the central issue that needed to be resolved, and therefore that there was nothing about the Credit Bureau case that would simplify the liability issues that the parties were still litigating. So I think the takeaway is when thinking about stays pending AMG Credit Bureau, whether liability is still an issue is an important factor. And the other important factor is the progression of the case. And the further along the case is toward trial, the more likely a court may be to find a stay is warranted. And Len, I believe you're turn it back to you to talk about the Blue decision.
Sure. And if folks have questions during the session, you can use the tool to post them, and we'll try to get to them if time permits. I should have said that at the beginning. So, needless to say, this is an interesting time at the Supreme Court, in trying to figure out how the court's going to rule on the Credit Bureau Center and AMG cases. We can look at the Liu case, which I'll discuss in a moment, from last term. The composition of the court is obviously going to change. Justice Ginsburg has passed. Judge Barrett from the Seventh Circuit has been nominated by the president, and her nomination appears that it's going to be considered by the Senate next month. As most of you probably know, she is a disciple of the late Justice Scalia, a strict constructionist, and one of the cases that Steve will talk about, the Galahad case, she took a very literal, strict, pure textualist view of that statute, which would seem to indicate that she would interpret the language in Section 13B that says injunction to mean just that, an injunction and nothing more. She had written a scathing dissent in another case involving the First Step Act, criticizing the judges there for sort of going beyond the language expressly used by Congress in the statute to expand the coverage of the statute. She was one of the judges on the Seventh Circuit who sort of implicitly ratified the Credit Bureau Center case. You would think, based on her academic writings and her leanings, that she would agree with Judge Sykes that statute should be construed neither broadly nor narrowly, but at the level of generality at which they are written. And here, where Congress at one point uses language like injunction, but in other places uses more broad language, that should dictate that Section 13B grants the FTC the authority to get an injunction and nothing more. But we'll see. There's a lot of ifs here. She needs to be confirmed before that becomes important. So that's looking forward. Looking back, we have some intelligence, we think, on how the Supreme Court might wrestle with these issues from the Liu case. Liu involved an action by the Securities and Exchange Commission where the SEC sought disgorgement as equitable monetary relief, and they sought the entire amount that had been raised from the investors in these cancer treatment centers, which was $27 million. And defendants were also ordered to pay civil penalties. The petitioners in that case appealed to the Ninth Circuit, which affirmed the restitution award. They then appealed to the Supreme Court, arguing that the Supreme Court, the SEC's authority to obtain injunctive relief is limited. This was not that essentially what the SEC, was seeking was akin to a penalty. And it's interesting to look at the statute that the SEC was relying on there, because it does contrast starkly with Section 13B. So Section 78 UD5 of the FTC Act states that in an action brought by the Commission under any provisions of securities laws, the Commission may seek, and any federal court may grant, any equitable relief that may be appropriate or necessary for the benefit of investors. And that language is very similar to the language in Section 5L of the FTC Act that deals with violations of consent orders, but it's very different from Section 13B, which simply grants the FTC the ability to get an injunction. So the Supreme Court agreed that disgorgement writ large was a tool that was available. It wasn't necessarily a penalty, and that under this provision of the SEC Act, the Securities and Exchange Commission could obtain disgorgement, but, and big but, it was limited. Rather than gross proceeds, which is the tool that the SEC had used and the tool that the FTC has used, the Supreme Court found that disgorgement must be calculated based on net profits from the wrongdoing after deducting legitimate business expenses. The Supreme Court found that to be disgorgement rather than a penalty, the disgorged funds must be returned to consumers where feasible. And this is important because in every FTC order, the equitable monetary relief provides that it may go to consumers for redress, but the FTC maintains discretion to not perform redress and instead to move the funds that have been paid into the general public treasury. The court also said that to avoid transforming what had to be an equitable remedy into a punitive measure, the imposition of joint and several liability should be limited. And it should be limited really to only those occasions where partners are engaged in concerted wrongdoing. And this is incredibly important as well, because the FTC has taken a very broad view, not just of the measure of equitable monetary relief, but the imposition of it. As I mentioned previously, the Ninth Circuit has authorized imposing joint and several liability, and the 11th Circuit has as well. And the 11th Circuit did it in a case involving a payment processor. So in that case, the universal processing case, the 11th Circuit ultimately upheld holding the payment processor fully responsible for the full amount of sales it processed, even though the money received by that payment processor was a small fraction of the amounts that it processed. And that kind of joint and several liability in the Liu case, the court indicates really transform what has to be an equitable remedy into a punitive remedy, which is not authorized by that portion of the statute. The Supreme Court did not give a great deal of guidance in lieu as to what constitutes a legitimate business expense. We expect to see litigation on that going forward, and you can expect to see what type of conduct is sufficient to be concerted wrongdoing for purposes of the application of joint and several liability. But in the FTC context, the FTC frequently brings cases alleging a common enterprise based on shared bank accounts, shared files, shared employees, and a commonality of operations. And it would seem that it would be that kind of situation, not just an arm's length business relationship, that ought to trigger that type of concerted wrongdoing exception to the ban on joint and several liability. So it's possible that the Supreme Court could find that Section 13B does authorize monetary relief, but it's limited by lieu, and that's certainly a probable or certainly a possible outcome. Judge Barrett's presence on the court could change how this gets sorted out, but you can see Justice Roberts trying to lead to maybe perhaps a compromise to get a lieu-like result in the FTC cases, and perhaps he won't need to do that now, given the presence of Judge Barrett. But again, that remains to be seen. There was a case involving a payment processor that applied lieu, and in dealing with the FTC in settlement negotiations and trying to litigate against them constantly, the party line is that lieu doesn't change anything. When you talk to them about settlement, they're like, nope, doesn't change anything, and their litigation position continues to be that lieu doesn't change anything. It applies to the FTC Act, not the FTC Act. when Chairman Simons went up to the Hill to talk about, what the agency might need from the Hill in the next couple of years, he was a little more candid and said that, lieu may indeed affect the tools available to the FTC, and asking essentially if Congress start working on legislation to give the FTC back the tools that the Supreme Court may take from it. But again, that hasn't happened yet. The EPS case was interesting because the court there noted that the reasoning underlying lieu was not unique to the FTC statute. Rather, it was looking at broad equitable principles and how equitable relief has been defined historically. And for that reason, the holding in lieu applied foursquare to the FTC Act as well. They found that whether you called it restitution or disgorgement didn't really make a difference. They're indistinguishable as equitable remedies. There might be a difference in certain legal remedies, but again, the division between law and equity that British and American courts have long recognized, is important in this context. On the partners in concert, this is a summary judgment ruling, and the court found that the record in front of it was not sufficient for it to determine that there was no genuine dispute of material facts about whether the two companies were partners in concert. So he sent that back for trial on that issue. But I think that the reasoning from the court in the EPS case is worth weighing heavily, because it really explains why the holding in lieu applies foursquare to the FTC Act. That may be superseded shortly by what happens at the Supreme Court, but at least for now, I think it's a good synopsis of why lieu should cabin the remedies available to the FTC. Let me talk briefly about the Shire Pharmaceutical case. This was in the Third Circuit in 2019. As we talked about earlier, Section 13B says that the FTC can go to court when they can prove that someone's violating or about to violate the law. This case was an antitrust case brought by the FTC going after conduct that had long ended and seeking dollars. And the court there ultimately found that the FTC had not pled facts indicating that the defendants were about to violate the law, and that about to violate means something more than just a past violation and the ability for it to occur in the future. Many of us thought the FTC would take this case up to the Supreme Court. They chose not to do that. Instead, what they've done is they make defendants who are subject to investigation sign tolling agreements that in some ways try to limit the passage of the defendants who point to the passage of time while the investigation is pending to support the argument that the FTC has failed to allege that defendants are violating or about to violate the law. But the rationale here and the reliance on the difference between Section 13B and Section 19 was really one of the keystones of the Shire Court's argument, and it's one of the keystones, obviously, of what the Supreme Court's going to be considering this term. And with that, I'm going to turn it over to Mary to talk about seal of law and independent agencies and their constitutionality or not.
Thanks, Len. So we thought we'd round out our discussion of the FTC portion of today's presentation by talking a little bit about some constitutional challenges to other independent agencies. And so I wanted to start today by talking about the CELA law v. CFPB case, which the Supreme Court just decided in its last term. The petitioner challenged the CFPB's structure as a violation of the separation of powers, and asked the Supreme Court to invalidate that structure. In its background, the CFPB is run by a single director. And so the Supreme Court ultimately agreed with the petitioner and found that the single director structure of the CFPB did in fact violate the separation of powers. And they set forth a two-pronged analysis to support that conclusion. And the first prong of that was that the CFPB's director wielded what the court called executive power. And the court gave as examples of this executive power the director's ability to set forth binding rules, to prohibit conduct, to unilaterally issue decisions awarding relief, both legal and equitable, against defendants in administrative adjudications at the CFPB. Then the second prong of their assessment is that the CFPB directorship is held by a single individual who cannot be removed by the president. And the court contrasted this to a multi-party, nonpartisan commission that was overseeing such an independent agency. So in finding that, so essentially the court said, you wield executive power, you're a single individual who can't be removed by the president, that violates the separation of power. Now, the court in its ruling gave the CFPB a mechanism by which to cure the constitutional defect. And essentially they said that the remedy could be as simple as converting the single individual directorship position into a multi-member panel, and that could be a way to resolve this issue without having to revisit the CFPB's authority entirely. And since this decision has come out, the Supreme Court granted cert on the same day that it granted cert in Credit Bureau AMG in the Collins case. And the Collins case is going to really essentially revisit this issue with respect to the Federal Housing Finance Agency. And there, the petitioner is similarly alleging that because the Federal Housing Finance Agency is an independent agency run by a single director who can only be removed for cause by the president, that the structure violates the separation of powers. It's going to be very interesting to see how the court applies the CLE law ruling, whether it expands the test, whether it narrows it further, and that could have important implications for for potential constitutional challenges to the structure of the FTC. As it stands, in applying the holding of CLE law, the fact that the FTC is overseen by a multi-party commission would seem to weigh in favor of of a ruling of constitutionality. But it is important to note that as part of the Supreme Court's ruling in CLE, it flagged its conclusion from a prior case, Humphrey's Executor, and noted that that conclusion regarding the FTC, whether the FTC exercises executive power, may not hold water as the FTC's power has evolved over time. So we'll be watching the Collins case closely to see if it has any limiting impact on the second prong of the CLE law test, as that could have some important implications for potential challenges to the FTC in the future. Now, before we transition to the TCPA portion of today's presentation, I'm going to read out the CLE code for today's presentation. And the CLE code is Supreme 2020. Again, the CLE code is Supreme 2020. And with that, Steve, I will turn it over to you.
Thanks, Mary. Thanks, Len. Hi, everyone. This is Steve Freeland. For many of you on the call today, you're happy that there isn't a video so that you don't have to stare at my dining room curtains like you have for the past 6.5 months during our Zoom calls. So let's talk about phone calls and text messages. We've had a flurry of activity both at the circuit level and more recently the Supreme Court under the Federal Telephone Consumer Protection Act. This was a statute, just by way of background, it was a statute passed in 1991 to address what was then perceived as a blitz of pre-recorded telephone telemarketing calls that were being made in high volumes by marketers, both domestically and internationally. Senator Hollings famously on the floor of Congress said, you know, they literally want to make you rip the phone out of the wall. Obviously, technology has evolved a tremendous amount since 1991, and we're still stuck with a statute targeted at 91 technology that really is extremely outdated. But what does it cover? So the TCPA, I always like to think of the TCPA as a fairly mechanical statute. What do I mean by that? What I mean by that is there's very few substantive requirements in the statute. It largely regulates the type of telephone equipment you can use, the level of consent that you need from someone you're calling, call time restrictions, as well as compliance with the Do Not Call registry, which I'm sure everyone is familiar with. It also regulates faxes, and for some reason, and maybe I'm just a little more modern in my thinking, we still do see a flurry of fax cases filed under the statute, and I largely thought that fax would have been replaced by other technologies, but there are certain industries that use fax, and there's good reasons for them to use faxes. So, but I'm going to focus largely on sort of the text and call side, since that's where we see both the majority of cases filed as well as the majority of potential liability. So the slide there sort of sums up what it regulates. And since the Ninth Circuit's ruling several years ago, a text message is considered a call under the TCPA, so there's no get out of jail free card to say, well, I'm only texting, it doesn't apply to me. It certainly does, and in fact, a majority of the cases that we handle now are text message cases. The statute is enforced by the Federal Communications Commission. At least the FCC has the authority to enforce it. That authority's largely been dormant for a while. Occasionally there will be a settlement that pops up on our radar, but the FCC spends the majority of its time attempting to interpret the TCPA. It does have the authority to do that where the statute's unclear. It can render decisions, sort of clearing up the ambiguity. It's done a not great job of doing that, and I'll explain why. And it also promulgates regulations under the TCPA as well. The majority of the enforcement liability really lies on the private plaintiff side. There are 10, 15 class action plaintiffs firms that do these cases in volumes, and they do them very well. There are also other firms that do them in volume that are not that good. The point being, in all this, and this is sort of the subject of a separate presentation, a lot of an ounce of compliance on the front end is going to save you millions and millions and millions of dollars on the back end. And sort of the easiest way to comply with the statute, it's really quite simple. I can sum up my usual hour-and-a-half presentation on compliance by saying just get prior express written consent to use automated and pre-recorded technology to call or text your consumers and potential consumers. Honor their opt-out requests, and don't call them before 8 a.m. Or after 9 p.m. local time of the call party. That you just got an hour-and-a-half worth of TCPA compliance in about 30 seconds. But the other important thing to remember is we're just covering the TCPA here. There are other statutes and regulations, most notably the Federal Trade Commission's telemarketing sales rule. That regulation has both mechanical as well as substantive requirements. For example, there are various disclosures that need to be said at the outset of sales calls. There's various levels of consent that need to be gotten before credit cards are charged, etc. Then there are also state laws that are different or supplements to the TCPA. For example, in California, you can't use an automatic telephone dialing system to call or text a Californian before 9 a.m. before 9 a.m. and after 9 p.m., whereas under the TCPA, it's no telemarketing calls before 8 a.m. or after 9 p.m. So that's just something to be aware of. The TCPA is a favorite of the class action plaintiff's lawyer because the pleading standards are fairly low to file a complaint. The cases can be fairly easy to certify as a class. And at $500 per text or call, the damages can get really large really quick. So you could have just one campaign of 10,000 calls or texts be done in violation or go awry, and you're looking at significant damages. Not to mention the fact that if you did it willingly or knowingly, it can go up to $1,500 per text. Importantly, there's no statutory cap on damages. There is, however, the due process clause of the Constitution. And interestingly, we actually were involved in a case a couple years ago where a defendant moved to, who we didn't represent, moved to reduce damages under a 1919 Supreme Court case, arguing that a $1.6 billion damage award under the TCPA was unconstitutionally excessive under the due process clause. The district court agreed and reduced $1.6 billion down to about $32 million, which was then affirmed on appeal. The other two cases there, Wakefield and Perez, very few of these cases get to a jury. Almost all of them are either dismissed, defense summary judgment decisions, or they settle, and the lion's share of them settle even before there's liability determination. So these are two new jury awards that have come out recently. The $925 million jury award in Wakefield there. The defendant just a few days ago moved for a retrial in that case, whereas the plaintiff said, we want the money, we want you to start distributing it now. It'll be interesting to see how the district court rules it there. The district court has not been a fan of the defendant in that case. And then in Perez, that $267 million jury award was not reduced under the due process clause. The defendant there filed a motion under that 1919 Supreme Court case, and the district court rejected it. So while there's no statutory cap on damages, you do have a due process clause argument, certainly far from a get-out-of-jail-free card. And if you're arguing under that 1919 Supreme Court case, you're probably not in a great place. And then right there at the bottom, FCC fines up to about $20,000 per call or text. But like I said, we don't see a tremendous amount of FCC enforcement. So the issue du jour, and this has really been a major issue in most of the cases we handle. If you look at the TCPA, there's really sort of two sides of it. There's the auto dialer pre-recorded voice message side of it. That's the technology side of it. And then there's the do not call side of it, right? And so the do not call case is I put my number on the registry. They called me with a telemarketing call, and therefore they violated the TCPA. We're not seeing as many of those of recent, but we're seeing almost all of these be auto dialer and pre-recorded voice types of cases. And the definition of an auto dialer, or in the statute it's called an automatic telephone dialing system, is right there at the top of slide 21 there. Quote, it's a system that has the capacity to store or produce telephone numbers to be called using a random or sequential number generator and to dial such numbers. That's clear enough, right? Yep, clear as mud. That language has resulted in probably well in excess of $1 billion in legal fees and expert fees, probably more, by lawyers, parties, experts, everything else over the past, 15 years as to what that actually means. And the FCC for years took a broad view of the scope of that definition. And basically they said it's a platform that has the capacity to dial lots of numbers in a short period of time without human involvement. Many members of the industry, trade associations, et cetera, challenged the breadth of that. The 2015 reaffirmance of that definition by the FCC. They took it to the DC Circuit, which, as many of you know, is kind of like the minor leagues for the Supreme Court, given the amount of federal government issues that they address. And the court came out, fairly with a fairly common sense decision, and it set aside the breadth of the FCC's, over decades long definition of automatic telephone dialing system, and said, look, this doesn't make any sense. This can't be reasoned decision making, and here's why. Under your interpretation, every American that has a smartphone, an iPhone, or whatever, is violating this statute literally every single day when they pick their phone up, because under your definition, smartphones and iPhones constitute ATDS, and it can't be Congress's intent to have interpreted this statute in a way such that every consumer is violating it every day. And so, importantly, they didn't actually, give a definition. They didn't say, unlike with the CFPB case that Mary was talking about, they didn't say, this is not right, but here's the definition. Where, in the CFPB case, they said you can't have, he needs to be able to be removed. We're not going to hold the whole agency unconstitutional. He's just going to be removable by the president. Here they said, FCC, try again, and they sent it back down. And the FCC now, for quite some time since that case was remanded, has had open a proceeding to try to get a better, more clear definition of ATDS. That the comment period's been closed for some time. This is an election year. I hardly anticipate that we're going to hear from them on the scope of this definition before the election. The way I've always looked at this definition is, and again, coming back to the fact it's passed in 1991, for those of you who are fans of The Simpsons, there's a famous episode where Homer starts to become a telemarketer, and he buys this device called the AT5000. And it literally dials 555-0001, 555-0002, and so on. So that's a sequential dialer, right? That's the way I've always seen it. That's the way that the defense bar has been arguing it for several years, and more recently has started having success. So we do have a very significant circuit split where we have the 11th, the 7th, and the 3rd circuits saying it's got to be like the AT5000 that Homer used. It's got to, generate numbers randomly or sequentially, and then dial those numbers. If you're the sort of punchline there is, if you're dialing from a stored list that was not randomly or sequentially generated, in other words, a list that came from people filling out lead forms online, or a list of existing consumers that have bought your products. If you're dialing from that type of list that isn't randomly or sequentially generated, and you've got a human that's involved in some level of initiating the calls and text, that's not an ATDS. That's not what Congress intended to target in 1991. Then on the right side there, you've got the 9th, the 6th, and the 2nd circuits who take a different view. And I'm going to talk more about do-good in a second, because that's the case that's now up before the Supreme Court. And here, these courts have said even systems that dial from a stored list of phone numbers that was previously existing, i.e. not randomly or sequentially generated, those can still be an ATDS. And the level of human intervention that's involved is relevant, but it's not necessarily dispositive. In fact, all of this really springs from the 9th Circuit's decision in Marks there, where the 9th Circuit actually hinted that this could be a jury issue, where usually how the device actually operates, how a telephonic system actually operates, and there's thousands of them out there in the market in terms of software and hardware providers. How the system actually works is usually not a question, a disputed question of fact. The mechanics of the system are the mechanics of the system. It's not like, there's usually a dispute about, whether the system can randomly or sequentially generate numbers. In fact, the dispute is usually about whether it has the capacity to, whether it's a current capacity or a future capacity. And what do I mean by that? What I mean, and this is sort of a hangover from the D.C. Circuit's decision in the ACA case we talked about a little bit ago, where they set aside the FCC's broad definition. They said, look, you can have a definition that says, does it have the capacity to generate numbers randomly or sequentially. But you've got to put a finer point on capacity. Does capacity mean you can flip a switch and then it automatically will start randomly or sequentially generating numbers? Or does it mean there's some, theoretical software patch that could be uploaded into the dialing system to then make it so that it generates numbers randomly or sequentially? And so that's usually where the dispute is, but that should largely be, something again that isn't a disputed fact. Theoretically, you could change any telephone probably into something that generates numbers randomly and sequentially, other than maybe the old-fashioned rotary dial. But what they're saying here in these circuits is, don't rely on human intervention, and if you're calling from a list of stored numbers that weren't randomly or sequentially generated, you could still be an autodialer. And so that's the circuit split that we're looking at right now. And so the do-good case that's referenced at the top there, Facebook took that case to the Supreme Court, and they granted cert this past summer. An oral argument was just recently scheduled for December 8th. Now, going back, actually, we go back to this Seventh Circuit decision by Judge Barrett in Gattlehack, as Len, previewed earlier. She took a very pure statutory grammatical analysis of the definition of ATDS in that case and said, you've got to generate numbers randomly or sequentially. If you don't, it's not an autodialer, period. And so, after that decision's issued, Justice Ginsburg passes away, and now Judge Barrett is up for confirmation. And if she is confirmed, she will be most likely confirmed before the election, and she will be on the bench to hear this case on December 8th. And if I was a gambling man, I'd be willing to bet $5 of Len's money that she would author the decision in the case, assuming that the rest of the conservatives on the bench and maybe even some of the Democrats on the bench agree with her definition of ATDS. I've got a summary there of the arguments that Facebook has put forward. And these are the textual arguments that most defendants have been making, and then that which is it's got a both that random or sequential number generator modifies both store and produce, which is contrary to how the Ninth Circuit and the Sixth Circuit and the Second Circuit have looked at it. And then there's the historical context. This gets back to the Homer Simpson AT5000, that the type of technology that's out right now was not envisioned by Congress in 1991. It was the AT5000. And then the last point there, it's similar. It's hinting at or in parallel with what the DC Circuit said in ACA, which is, wait a minute, like we're getting closer, if not we're entirely back to where we were before the DC Circuit issued ACA. You're casting too wide of a net as a result of these broad definitions over technology that, ordinary consumers could be using every day unknowingly, and that cannot be, a reasoned interpretation. And so this one actually made me laugh out loud. So the Department of Justice has intervened in the case, and literally, like, just before the Labor Day holiday, they sort of, knock on the Supreme Court's door and say, hi, we're from the government and we're here to help, but we really don't want anyone to find out about it. So we're doing this, on the eve of I think it was Friday before Labor Day weekend. Obviously everyone was going to find out about it. It was just interesting to me as to when it was filed. But the DOJ agrees with, Justice Barrett agrees with the 11th Circuit, and has taken the very limited, narrow view that if it doesn't generate numbers randomly or sequentially, then it's not an ATDS. And they also, and their brief is actually it's really well written, and it's really well reasoned, and it's very easy to understand. They make both the grammatical argument, the English language argument, where the comma falls, etc., as well as looking back at the legislative history, and also looking at the state laws that were in effect at the time that Congress, was sort of looking at when they drafted the TCPA. So we've got, the federal government telling the federal government that it should be the narrow view and not the broad view. And so the defense bar quite wisely, and as I said, the great majority of TCPA cases that are filed under that auto dialer restriction. The majority of them involve text messaging rather than, do not call or pre-recorded voice. There's still some pre-recorded voice tag-alongs on the ATDS because the plaintiffs will argue, well, the call was made using an auto dialer and it also included a pre-recorded voice. I didn't consent to either. But the defense bar said, well, we got to go and start moving for stays in all of our cases, pending what the Supreme Court's going to tell us on the definition of auto dialer. And the argument there that they're making is, look, why should we waste our time and money, your time, Your Honor, and our experts' time and money in looking at this technology, rendering reports and making arguments, applying a standard that may be completely different in a few months? That's the rationale, is we're going to save a lot of resources. The majority of courts, and right here on this slide and the next one, these are the ones that we're aware of. I think that this is most, if not all of them. As you can see, not a lot of them are granted. We've got most of them are denied or pending, and the reason that they're being denied largely boils down to this: district court judges have an incredible amount of discretion to control their docket, which includes the ability to stay cases pending higher court review of an issue that could be dispositive in the case or which could materially advance the resolution of the case. And I think what a lot of these judges are doing is saying, all right, look, I'm denying without prejudice. You guys keep going through discovery because there's other things that we're going to have to do regardless of what the Supreme Court says. That's somewhat of a farce, particularly if it's only an auto dialer case. Because, for example, if it's not in question that the system does not randomly or sequentially generate numbers and call them, that the system only dials from a stored list of pre-existing numbers, then the case should be dismissed. And so sort of spending money on the other aspects of discovery and sort of holding up expert discovery, for example, until the Supreme Court gives a clear standard of what the experts should do, it's a little bit of a farce. But, again, district judges have a wide amount of discretion to stay cases or not. It's almost, regardless of whether they decide to stay or not, it's almost bulletproof on appeal, whatever they do. I mean, that's really how much discretion they have. There's been, a few instances where appellate courts have disagreed with a district court, denying a stay pending a potentially dispositive higher court decision. But that's, again, those are outliers. Before I get to this last slide,
I'll just jump in, if you don't mind, interrupt you for a second. Someone has noted that when I read out the CLE code earlier that I broke up, so I'm going to repeat it again. The CLE code is Supreme 2020. And Steve, I'll also note that the chart, the do good stay chart, there are a lot of motions where the parties consented to a stay, and so this is really this chart was really intended to focus on the opposed motion.
Yep, no, that's exactly right. So I wanted to come back to slide 22 because I want to give a little bit of a practical observation here. Where does this all leave us, right? The Supreme Court is going to tell us one way or the other, because the issue that's at issue in all of these cases is going to be decided and it's going to be resolved. And our best estimate is if it's resolved in favor of what I'll call industry, meaning it's resolved narrowly, right? The Judge Barrett authors a majority decision that says, it's the narrow definition. There will almost certainly be a congressional fix that will, broaden it out to include other devices that may be able to dial a lot of numbers quickly, since that's really the issue. Now, the scope of that congressional fix, if there is one, and again, we believe there will be hotly debated. And unlike in 1991, I imagine that there will be a lot of people, making virtual trips to the Hill to lobby their respective congresspeople and senators to try to get a more common sense definition that's easy to follow, because the one that's on the books now, while we contend it's the narrow definition and the plain English language of it is the narrow definition, it's been hotly litigated. It's cost litigants and probably billions of dollars in fees and in judgments and settlements and everything else. And so there needs to be a clear definition. But from now until the Supreme Court rules, where are we? So if you're using a dialing system in the 11th Circuit, in the 7th Circuit, and in the 3rd Circuit, there's a lot of states in those circuits, and you're only calling consumers in those circuits, and you're calling from a list of stored numbers, and you've got some level of human intervention to get the calls going or the text out, you're probably pretty safe. If you're in the circuits on the right, you're not, which leads to, it's somewhat of an absurd result, particularly given that California, the 10th largest economy in the whole world, at least a few years ago, is in the 9th Circuit. And so it would be best, since we're sort of on the cusp of getting a decision and looking at the construct of the court, likely a decision that's favorable to industry, to be very conservative in those circuits. Or, as I said earlier, you just get the prior express written consent of the people you're calling or texting to use an automatic cell phone dialing system or a pre-recorded voice to call them for telemarketing calls. So that's sort of the practical takeaway of where we are. And then just moving forward again, another interesting development more recently at the Supreme Court, and this actually came out a few weeks ago, is what's called the Barr decision. And the issue in this case involved a government debt exception to the TCPA. No one takes care of the government like the government. And so a few years back, the government decided, well, we can't have the TCPA applying to us if we're calling or texting, using an auto dialer to collect debts that are owed to the federal government. So let's put this exception in there that says, yeah, those restrictions don't apply to us. So, for example, if the government's calling a student to collect on a college loan or a law school loan or whatever, that exception wouldn't apply to that. Or that exception means the TCPA doesn't apply to that call, and the student can't sue the government. Well, a trade association got together and challenged that provision under the First Amendment and said, look, this is an unconstitutional content-based restriction. It's the content of the call that governs whether or not there's a violation, and that's not proper. And so the way that the court came out, and again, I think that this was a fairly common sense decision. And I've got a quote there from the opinion. A robocall that says, please pay your government debt is legal. A robocall that says, please donate to our political campaign is illegal. And then, because the law favors speech made for collecting government debt over political and other speech, the law is a content-based restriction on speech. So the challengers in the case really went for the gusto and asked the Supreme Court to declare the entire TCPA unconstitutional based on this government debt exception to the restrictions on ATDS and robocalls to collect government debt. But similar to what Mary was talking about earlier in the CFPB case, the court used a scalpel rather than a hammer, and just said we're just going to take that exception out, and for two reasons. One, the Communication Act has a severability clause in it, which the Communication Act was passed in 1934. The TCPA is under the auspices in Title 47, which is the Communications Act. And so because it has a severability clause, Congress clearly intended for the court not to use a hammer to take down the whole statute, but rather to use a scalpel. And then there's a body of case law out there that, says courts should be wary to declare entire statutes unconstitutional if, the provision in question can be just, removed out of it without impacting the rest of the statute, and the court concluded that that was clearly the case here. And so in terms of sort of wrapping up this side of it, and I'll turn it back over to Len here in a second, and we can also take any questions that the group may have. We've seen this Supreme Court, not just in the FTC Act side and TCPA side, but others, really, taking a very narrow approach to interpretation and construing statutes strictly. And that's not surprising, given that we have a majority conservative bench, and there's, strict constructionists that have been on the bench a long time, like Justice Thomas. And our best bet is we see something similar with respect to the FTC Act and the TCPA. At a minimum, we're hopeful that we're going to get a lot more clarity as to the FTC's authority under the existing statutory regime, as well as definitions of crucial terms that are at issue in the majority of TCPA cases, which again, at $500 a violation, can turn into bet the company cases, even for large companies, real quickly for one campaign that goes awry or one mistake was made because someone called the wrong list or texted the wrong list using the wrong technology. That being said, we also do anticipate, and Len was discussing this a little bit earlier, we also do anticipate that even if there are favorable rulings here, that there'll likely be congressional, what I'll call fixes, for lack of a better word, on both sides of this, both the FTC Act side as well as the TCPA. But hopefully, if that is the case, there will be meaningful participation by both the consumer groups, who are well represented, as well as industry, who is also well represented, not just by us, but by other firms, in participating in and hopefully, coming to a more common sense approach and a clearer approach in the legislation. So with that, Len, I'll turn it back over to you.
Thanks, Steve. That was great. Just a couple of closing thoughts on some of the statutory issues. Whether if the Supreme Court guts or severely limits the FTC's ability to get equitable monetary relief under Section 13B, how Congress fixes that will be interesting. Obviously, it would depend on what the Supreme Court does, but the imposition of a statute of limitations and the imposition of some benchmarks and criteria the FTC has to hit, or limits on what it can receive, would certainly be better than what's there right now. Another issue to keep your eye on is who represents the FTC at the Supreme Court. Historically, the Office of the Solicitor General is the lawyer for governmental agencies before the Supreme Court. The FTC represented itself in filing the cert petition, probably because the Solicitor General had urged the Supreme Court not to consider the AMG case until it ruled on the Liu case. It's possible that the Solicitor General's office and the FTC have a difference of opinion on how Section 13B ought to be construed, and in which case the FTC would represent itself, but the Office of the Solicitor General might be asked for its views by the court. But we probably won't know that until the brief gets filed for the government. That's a little ways off. Both the Office of the Solicitor General and the FTC have already entered appearances, so can't tell anything from that. Steve, there is a question to you. I don't know if you want to answer it.
Yep.
in the chat.
Sure.
About prior express consent, but it looks like we've got time to do that, so might as well.
We do, and this is a question that it's ironic. I just got this question from a client last week. So the question for the group's benefit is, if I get prior express written consent to SMS a consumer, and they later register on the federal do not call list, can I still rely on their prior consent? And the answer is yes. That the consent that's given if you get prior express written consent properly, and what I mean by properly is you tell the consumer in writing, and it can be over a website or a lead form, by providing my number and checking this box, I expressly consent to receive telemarketing calls on the number provided, including telemarketing calls initiated through an auto dialer or using a pre-recorded voice message, and I understand that, my consent is not a condition of purchase, and they check the box, that prior express written consent is good forever unless and until they revoke it. And what I mean by revoke it is everyone gets text messages from marketers that say text stop to stop. If they text stop, that consent is no longer valid. It's revoked. And then if you're in compliance with the TCPA's internal do not call policies, you would disposition that number do not call, such that all of your marketing agents or anyone that's trying to contact that consumer, no longer contact them. And I would interpret that as don't contact them at all for marketing purposes, whether you're using an auto dialer or not. You should have a very conservative, or interpret their revocation broadly to mean I don't want you to call me at all for marketing messages. Now, if they've got an account with you and you need to update them on their account, for example, banks are a classical institution here. If you get a text and say, hey, your account balance is getting low, you can do that. You just can't call or text them for marketing purposes. And so, like I said, the consent sort of is it is the greatest field that any marketer can use, regardless of whether it's on the auto dialer pre-recorded voice side or the do not call list side. That applies to both sides. You just have to make sure you're using the right consent language. It's clearly and conspicuously displayed. The consumer is providing a signature, which can be electronic. It can be that checkbox, like on a lead form and a submit button, and that you honor their revocation, any instance of revocation, and disposition them do not call. Now, if they come back to you and give you what we call fresh consent, then it all starts over, right? And then that consent is good, forever. But once they revoke consent, that's going to trump even the do not call registry on that, because that's the consumer expressly telling you stop calling me. But that's a good question.
Thanks, Steve. Are there any other questions? If not, we'll give you back 3 minutes in your day. Thank you all for joining us. Don't forget there's sessions tomorrow on COVID and Thursday with the attorney advisors, the people who advise the 5 commissioners of the Federal Trade Commission. Should be really inside baseball stuff.
Len, can I steal at least 1 minute back from the audience? We've got one more question.
Yeah, sure, go ahead. Absolutely.
Which is, and this is another good question. Can you give a 30-second summary of FCC law you mentioned earlier covering same or similar areas of TCPA? I think they meant FTC law there, because the FCC is the TCPA. They promulgated regs that just put finer points on some of the provisions in the TCPA, and they've also entered declaratory rulings on certain definitions, such as automatic telephone dialing system that we talked about earlier. So the telemarketing sales rule, it also has a do not call provision, so you've got to comply with the do not call requirements there. They're nearly identical to the TCPA. There's also restrictions or requirements on if you're calling to sell someone something, you've got to say, hi, I'm calling from XYZ company. I've got a great deal for you today. Would you like to discuss it? This something separate and apart from the telemarketing sales rule that the group should be mindful of is if you're going to record your sales calls, and there's a lot of benefits to doing that, particularly if you have a good compliance program. You should disclose that at the outset of the call as well, that the call will be recorded for quality control purposes. There are some states where that's not required, but I advise my clients just go ahead and be clear with the consumer unless there's a reason. You've also got to, if you're going to be enrolling someone in a recurring billing program, you've got to disclose the recurring billing program clearly and get their agreement to it clearly, and get a record and get a record of it. Again, that's the benefit of recording at a minimum that portion of the call. So you've got an agreement that's quote unquote in writing, because a telephone recording does constitute a quote writing or a written agreement under the E-Sign Act, and that's E-SIGN. And so those are the material requirements, as well as any restrictions on refunds and cancellation, right? So it's basically describing accurately what's being sold. It's describing accurately the billing, and it's describing accurately how to get a refund and cancellations and any restrictions on the same.
Super. Thanks, Steve. So thanks to all of you for joining. Thanks to our great team here at Venable for all the hard work they did to make this run smoothly. Don't forget about the programs the rest of the week. You'll be getting an email with a link to the recording if you can't get enough of us and want to listen to this all again or share it with your colleagues. Thank you again. I hope everyone stays healthy and safe, and we'll be talking to all of you soon. Thank you very much.